Good morning, good afternoon, good evening. Welcome to my YouTube channel. My name is Ogbanje Joseph. Please hit the subscribe button to subscribe to this channel, like and share this video as well. Today we are going to be looking at the argument: is international law or not? Is international law or not? Okay, one of the things that have been a, a source of argument for scholars is whether international law is law or not. Okay, now the first argument is, what is the body of law? In fact, what constitutes a law? you know what constitutes a law is that the law must actually follow the norms and traditions of the people. The law must actually be enacted, okay, by either the representatives of the people, or by the people themselves, or sanctioned by the people. A law must also be codified. Okay, a law must be based on the customs, the customary practices of the people. Okay, and the law must also be enacted. Okay, now is international law does international law follow all these procedures, all these processes that I just talked about? Of course, yes. International law actually, there are body of rules that actually guide the intercourse of countries, okay, in their interactions with themselves. Okay, so however, international law lacks, institutionalized enforcement like the police force or court system. And that is why a lot of people actually look at it that international law is not a law, because you know, number one is the fact that it lacks enforcement framework. You understand? There's no institutionalized, enforcement institution like the police force or the court system, that actually can hold people accountable. They, apart from the fact that international law does not have all those enforcement institutions. The subject of international law is states, and states are not human beings that can be arrested. States are not human beings that can be punished. And so, to that extent, you cannot call international law. However, in as much as international law does not have enforcement institution, enforcement framework and all of that, it does not mean that international law is impotent. There are some inbuilt proceedings that actually are put in place to actually checkmate the activities of countries based on this international law. Number one is the Security Council. The UN Charter has provided that the Security Council, may take enforcement action against the state where, where it poses a threat to the peace, or committed to the use of force, or an act of, when a state actually poses a threat to the peace, or has, committed an act of aggression or breached the world peace. Okay, now a very good example is actually the military action, or the military action in Korea in the 1950s, Iraq, Iraq in 1990s and 1990, 1990 and 1991, and also economic sanctions, okay, as with trade restrictions, okay, and embargoes against South Africa in 1977. All of these things are actually enforcement mechanisms that have been put in place by the Security Council. So to this extent, you can say that international law also have, enforcement institutions, okay, or institutionalized enforcement agents, okay, or agency. Number one of it is the Security Council that I just talked about. That is number one. Number two is loss of legal rights and privileges. Loss of legal rights and privileges. Now, what does this mean? This is where if state A violates the terms of commercial treaty, okay, with state B, then state B can be entitled, okay, can be entitled to suspend preference of obligation it owes to state A. This may also involve termination of diplomatic relations, restriction on economic, and cancellation of supply engagements. Okay, now in 1982, UK broke diplomatic relations with Argentina after its invasion, on Falkland Island. Okay, and also in 1979 and 1980, the US freezed Iranian assets. Okay, Iranian assets after the unlawful seizure of its embassy in Tehran. Okay, it can also lead to expulsion from intergovernmental organizations. Example, when the International Atomic Energy suspended, okay, Israel after the unlawful attack on Iraq nuclear facilities in 1981. So loss of legal rights and privileges actually is one of the things that have been put in place, to actually checkmate, okay, countries that do not want to follow international law. So to this extent, you can actually say that international law has an enforcement mechanism. Okay, that is number two. Then number three, judicial enforcement. Although the procedure by which states can be compelled to carry out, awards of the court is very limited. Nevertheless, states have continued to be bound by judicial decisions by either the court, that is ICJ, or ad hoc tribunals for the sake of maintaining their rights to exist. Other ways in which international law, may be active. Okay, other ways in which international law may be active are, number three is common good. Okay, but before we even go to common good, let us talk about that judicial enforcement. The International Court of Justice can actually make a particular pronouncement, and that pronouncement is expected to be obeyed by the country that it made that pronouncement against. For example, the ceding of Bakassi Peninsula, or yes, the ceding of Bakassi Peninsula to Cameroon by the International Court of Justice. Now, that judicial enforcement, that is judicial pronouncement, and that judicial pronouncement has to be enforced. Of course, if it is not enforced, of course, the country involved will actually be held responsible. Okay, so those are just the major things. Now, that is number three. Other ways in which international law can be effective, that you can say international law is law, is another way is common good. Due to the growing interdependent nature of the global system, it is being recognized that the effectiveness of international law depends on common good, or self international recognition, that the effectiveness of international law depend on common good, or self international interest and necessity. What does that mean? The common good here is that it will be in the common interest of everybody, of all states, for countries within the international system to obey international law. Otherwise, it will not be to the common good, the common interest of everybody. At the end of the day, countries will actually be locked in conflict that will be unnecessary. Okay, another point is political cost. Now, apart from the legal sanctions that might be imposed, there are other political and economic costs to be paid. The loss of influence and the loss of trust consequent upon a breach of law may mean a reduction in overseas trade, loss of foreign aid, and or a refusal, of many states to enter into new treaties with the states or negotiations, or some other matters, because it has a history of violating existing agreement. That is the political cost. Political cost, or the political implication that makes the international law to be fact, to be law, is that, of course, countries will not want to be named barrier nations. And so because of that, a lot of countries will actually want to obey international law, because you wouldn't want to be blacklisted. You wouldn't want to be named as or known as a country that has a history of not obeying international agreements and all of that. So that is actually for that. Then mm, we also have another point, okay, which is law as self-perpetuating quality. This is about the fact that there is a psychological barrier against breaking international law simply because it is a law. It is a state, okay. Now if a state embarks on such course of conduct, its action will be described as unlawful or illegal. You understand? So those are the things. But these are the these are the things. Law as self-perpetuating quality. Because they are just laws, you are under that psychological obligation to obey it. Okay? But what are the weaknesses of international law that makes it not to be law? What are the weaknesses of international law that makes it not to be law? No, it may be erroneous to conclude that international law is a perfect system of law. Okay, indeed, it contains its own weaknesses. What are these weaknesses? Number one, lack of institutions. I've talked about that one already. There is no formal legislative body, no compulsory court machinery, no police force, absence of central organization responsible for law creation. Hence, lawmaking process may be too slow when new rules are needed. So number one is lack of institution. Number two is lack of certainty. You understand? Lack of certainty here is that what applies to one in one case may not apply in another case, because of the exigencies of the time, because of how dynamic the international system is. You find out that countries keep changing from time to time. The way all the countries of the world will actually attack a country for not obeying international law will be different from the way they will also attack other countries. For example, if America, for example, actually disobeys international law, the way people actually states will raise eyebrow against them will be different from when Burkina Faso or Mali refuses to obey international law. That's lack of certainty. Then number three, vital interest. Because there are no institutions, the tendency to violate international law is greater than the municipal law. You understand? So vital interest of countries, that is what matters, at that level. Then number four is vital rules. In municipal law, there exist certain rules that prohibit certain conduct so as not to destroy the society. Example, the existence of rules prohibiting modes of the use of force. International law seems to be toothless in preventing major ruptures of the fabric of the international system. Okay, so there are no vital rules when it comes to international. So because of the weaknesses of this international law, you can actually argue that international law is not law. But because of the strength, those machineries I talked about, you can also argue that international law is law because of those arguments. So it is neither here nor there, but at the end of the day, you need to actually take a position. And what is the position? The position is that international law is law because of Security Council, laws of legal rights and privileges, judicial enforcement, common good, political cost, law as self-perpetuating quality. Now, international law is not law because of lack of institution, okay, lack of certainty, vital interest, vital rules. Thank you very much.